On October 22nd, 2024, about 19 states in Nigeria filed a suit at the Supreme Court to question the legal stand or legality of the Economic and Financial Crimes Commission (EFCC) and the Independent Corrupt Practices and Other Related Offences Commission (ICPC). It should be noted that some states have questioned the EFCC's legality and impartiality on several occasions. States like Rivers, Lagos, and Kano State, pointing at selective prosecution, political bias, disregard for due process, and overreach of power. Should EFCC, ICPC, and others be scrapped or termed as illegally established agencies for their abuse of power, bias, selective prosecution, or be allowed to exist but with proper flush out of impunity? Welcome to Let's Talk Politics on Niger Anchor News. Kindly share your opinions and comments with us. The states involved were Kogi, Kebbi, Katsina, Sokoto, Jigawa, Enugu, Oyo, Benue State, Anambra, Plateau, Cross River, Ondo State, Niger, Edo, Bauchi, Adamawa, Taraba, Ebonyi, and Imo State. This move, which was led by the Kogi state government, being the first plaintiff, raised 6 issues on the grounds that the Economic and Financial Crimes Commission was not well-founded, stressing that the commission is a product of convention. Also challenging the foundation of those laws that created the Nigerian Financial Intelligence Unit, NIFU, EFCC, and the likes of others, claiming that they were not well-founded and should be discounted, as it was never intended to be a law applicable throughout the country but to protect Nigeria's resources from being taken out of the country. They also sought a declaration that the EFCC, NFIU, or any agency of the federal government cannot investigate, requisition documents, invite or arrest anyone for offences arising from or touching on the administration and management of funds belonging to the state. Among the states involved in the suit, Nasarawa and Ogun State had separate requests by specifically challenging the Nigerian Financial Intelligence Unit cash withdrawal limit guidelines, which was later dismissed. And while the other states challenged the agency's constitutionality, the court held that, in a country like Nigeria, the federating units do not have absolute power. The NFIU guideline is to present a benchmark and not to control the funds. Where an act of law is made by National Assembly like the NFIU and its guideline, it is binding on all. Any act that has been competently enacted by the National Assembly cannot be said to be inconsistent. The court also went further to differentiate a convention from a treaty, stating that conventions are agreed by a larger number of nations and they only come into force when a larger number of countries agree. Therefore, the EFCC Act, which is not a treaty but a convention, does not need the ratification of Houses of Assembly as earlier requested by the state. However, in the days that followed, 6 states consisting of Adamawa, Ebonyi, Anambra, Jigawa, Benue, and Enugu State withdrew from the suit. Before Benue State's withdrawal, the Attorney General of the state and Commissioner of Justice and Public Order, Fidelis Inyim, was suspended by his principal, the Most Honorable Governor of Benue State, His Excellency Hyacinth Alia. The commissioner was suspended for joining the suit, challenging the legality of the Economic and Financial Crimes Commission without informing the governor. But it was on Monday the 11th of November in Makurdi during the State Executive Council meeting, which the Benue State Governor presided over, he announced the Attorney General's reinstatement, thereby marking the end of his suspension. Considering the fact that the commissioner also met the requirements for his reinstatement, one of which was to withdraw Benue State from the list of states seeking constitutionality of the laws establishing these 2 bodies. Nevertheless, in recent turn of events, after weeks of waiting for the Supreme Court's reserved decision, on Friday being the 15th November 2024, in a unanimous decision led by Justice Owani Abaji, the 7-member panel dismissed the suit for lacking merit, which indicates that the decision applied to all the states involved. The 6 issues raised were being resolved as the court ruled that the laws establishing the EFCC and other anti-corruption agencies were validly enacted by the National Assembly within its legislative competence, as the decision was in favor of the Attorney General of the Federation. However, would it be fair or right to flush out these agencies, or could it be that the government officials in question are scared that these agencies have been exposing their hidden deeds? Also, in regards to the Supreme Court's decision, what are your thoughts? Share your opinions with us and stay tuned to Niger Anchor News for more political and policy issues on Let's Talk Politics.